the unfun task of getting between people and the attorneys and law adjacent folks getting between their arguments and their food. So hopefully you're now full enough that that's not a big issue. We're going to move on to our next session about legal education and innovation. I will first say you get to, not only do you get to take that handbook home, you can take a dice home. So, ooh, the table settings are takeable. That being said, I'll let our panelists up here know. The panelists all have lavaliers. They can pin them on. Just make sure they're on when you want to talk. Okay. So I'll go ahead and Dyane O'Leary, the director of our Legal Innovation Technology Center, is going to take us away. And so, Dyane.
All right, I'm going to give our esteemed panelists 1 minute to get set up, and then we'll get going. So for those that weren't here this morning, my name is Dyane O'Leary. I have the privilege of directing our Legal Innovation Technology Center here at the law school and getting to work with a lot of the great folks and the students that you've heard from today. Dean Perlman mentioned them earlier, but yet again, I want to especially thank Quinten, David, and Sam for their efforts. Without their efforts, this conversation, these slides, these demos happen on LinkedIn, and that's about it, right? So thanks to them, we are here today kind of enjoying the space and collaboration. So I wanted to pause and invite us to recognize all of them with a nice round of applause. Thank you. So we have the privilege of trying to keep you awake now after lunch, always a challenge. And what better way to do that than the dynamic, exciting, cutting edge subject of legal education, right? As some of us know, legal education has a rap for looking the same as it's looked for 100+ years. Dean Perlman this morning mentioned that 10 years ago, we started a new lit concentration. Now more and more law schools have pockets of this, maybe an e-discovery class, a digital evidence class. But this panel is going beyond just pockets and is really diving in, and we're excited to share what legal education can look like today. And dare I say, maybe inspire some of us to get more involved with these efforts at local law schools that are specific to your area. So with that, to introduce our panelists, we're going to, in the spirit of David, he's contagious, we're going to play another little game. And the game is Guess Who? So I'm going to give you the 4 hobbies or 4 fun facts about our panel. And in your mind or with your colleagues at your table, you can think and play a little game of Who's Who. One of our panelists lists as hobbies woodworking, hiking, and designing new board games. Another one of our panelists rides a motorized e-bike, 8 miles to work most days. Another panelist has been a competitive Scrabble player and indeed used to organize a Scrabble club. And then finally, our 4th panelist has been bungee jumping with law students in a trip to South Africa. So lots of good guesses. I will turn it over first to Nick Hafen from BYU Law School and invite Nick to own one of those hobbies and very briefly introduce himself and tell us a little bit about his program at BYU. And then we'll dive deeper. This session was built for a post-lunch interactive fireside chat, if you will. So that's the model we'll cling on to. So Nick, welcome.
Thanks, Dyane. I feel pretty pedestrian after hearing all those. I enjoy woodworking and hiking, and I should clarify that designing board games mostly means changing the games that my kids are playing so that they are cooperative instead of competitive games. For my own sanity, you know, and theirs too, I guess. I'm the head of legal technology education at BYU Law School. I teach a lot of technology classes on law practice technology. I teach our AI class, and I run our LawX program, which I'm going to talk about today.
All right, thank you, Nick. April.
All right. Good afternoon, everyone. Thank you, Dyane, David. I have been wanting to come to this conference for years and years. I can't believe this is my first time because you all are my people, and this has been absolutely wonderful. My name is April Dawson. I'm the Associate Dean of Technology and Innovation at North Carolina Central University School of Law. And I went bungee jumping in 2014 in Soweto when one of my colleagues organized a trip to South Africa. So I was terrified, but I got mega cool points from my students. We have at Central a Technology Law and Policy Center, which was started in 2021. I'm looking forward to doing a deep dive and talking a little bit more about our law and technology certificate. I've been at the law school for 18 years. I have taught torts, started off actually legal writing, torts, constitutional law, administrative law. I now teach all things AI and the law, AI legal reasoning, legal technology, equity and leadership, AI governance. And yeah, I'm looking forward to talking more about our program.
Thank you, April. Like I said, law school has changed slowly but surely. I'll pass over to my colleague, Quinten.
I am Quinten Steenhuis. I'm the co-director of the Legal Innovation and Technology Lab, along with David Colarusso, doing an excellent job running the conference today. And I also have the distinct pleasure of being able to teach several classes that Mark Lauritsen originally created that have been taken over by other people before me, like Gabe Tenenbaum. So as co-director of the Lit Lab, we spend half of our time doing projects, partnering with courts and legal aid programs around the country. A lot of that's project-specific work. We're also building infrastructure. I think it's one of the ways that we distinguish our program is we will do what we can to see new innovations through to the on-the-ground implementation. And I also get to work with students working on some of those same projects. In my seminar, we're helping teach basic legal technology skills, exposing them to as many things as we can, helping them have the basic practice competence skills that we need to be lawyers in today's world. So that's what we do. And my hobby is I love words, and I was a Scrabble player, competitive for a little while, and used to run a club pre-COVID. Unfortunately, did not resume after that.
He's a Scrabble guy.
I'm the Scrabble guy.
All right, and from across the river, we'll welcome Jack Cushman from the Harvard Library Innovation Lab. Welcome, Jack.
Thanks so much. Yes, Jack Cushman. I direct the Harvard Library Innovation Lab at the Harvard Law School Library. So if you're keeping track of the hobbies, I do ride a off-road fat tire e-bike 8 miles from Dorchester across the river to Harvard campus and back. And rain or shine, I'm out there. So give me a wave if you're in the Boston area and see me zoom by. It is the most cyberpunk and fast way to get around Boston. Recommend.
And your colleague Quinten is fist pumping because he also has been known to ride his bike to Suffolk Law School.
A little shorter.
It was not always a fat tire e-bike, but the roads are gnarly out there, and it's a good way to get around. So directing the Library Innovation Lab, we exist to bring library principles to technological frontiers, which means finding people where they are in their knowledge and information needs, and building new tools to meet them there and to help them. So a lot of what we do is building and running platforms. We run PermaCC, which is used by the federal courts, by many state courts, and most American law journals. We build H2O Open Casebook, which is used by a few dozen faculty every semester to make remixable open Creative Commons licensed casebooks for their classes. And we made the Case Law Access Project, which scanned all American case law up through 2018 and made it available now as an open data set that is powering this generation of legal tech startups. We get to work with students less than I like, and I think we can talk about that here. But I have taught a programming for lawyers course at the law school to promote design thinking. And I run the Legal Hackers Club. We've tried an experimental club this year to try to bring in students thinking about law and law and tech from a new perspective. So really excited to think about how to reinvent legal education with what we're doing.
A small task, just a small task, Jack,
Mhm.
reinventing legal ed. Nick, if I can turn it over to you, I asked each panelist to drill down a little bit more as to what their program does. What does it look like? What are the nuts and bolts? Give us some examples of projects. So I'd love to get a little bit more detailed and help the audience picture what we're actually doing all day when we talk about these initiatives.
Yeah, LawX started back in 2017 when I was a law student and a member of the first LawX class. It's called the Legal Design Lab, and we start by picking a problem at the beginning of the semester. That very first class, we picked the high default rate for debt collection lawsuits, and we dive into the problem, try and understand it, and over the course of a semester, come up with some kind of prototype of a solution. That's a very rough prototype that it could be a PowerPoint or a wireframe, something representing the proposed solution. And so we've done that every year since then. And just this last year, we started a new class called the LawX Incubator that kind of picks up where the design lab leaves off. People come in with a project idea, with a solution that they'd like to build out, and continue building that out, from prototype to product, when it is a product. That first class resulted in Solo Suit, which is a company that still operates today, helping people respond to debt collection lawsuits and negotiate debt settlements. Bob Ambrogi was there. He visited our class that first year and wrote about it. And he's written about it a few times since then, which is great. So it is in the form of a class. It's a clinic at the law school. It's pass-fail. We get about 10 to 15 students every year. We've been experimenting a lot about which semesters do we offer which class. And so, doing small iterations, just like Kristen talked about this morning.
April, I'll turn it over to you. If you can pick which hat to wear, or how many hats of what you do at NC.
I'm gonna go over
Please.
to let's see. Let me grab this. Oh, and I don't need that. Okay.
And April did provide me a picture of the bungee jumping, which now I regret not pulling up because now would have been a great time to just showcase the bungee jump itself. But you'll have to trust but verify later.
Okay, great. That's okay, perfect. So this is the LibGuide, the student LibGuide for students who are interested in earning the Law and Technology certificate. So I thought this would be kind of helpful as I go through the program that we have. So I mentioned we have our Technology, Law, and Policy Center. One of the things that we do is we encourage all of our students to take at least one, preferably two, law and technology related classes, because of course, as we know, technology is disrupting all areas and especially the legal area. But for those students who want to do a deeper dive, we've got this certificate program. And this is a picture of our second class, which was May of 2024. This isn't all the students, but we had about 25 students. The first cohort was, I'm going to say 11 students, and they actually started their 2L year. So these were students who were 1Ls when we started the program. And we're on track to have about 21 students graduate this year in the program. And as far as the structure of the certificate, so the students have to earn between like 12 to 13 hours total of law tech related courses. Some of those overlap other required courses. So we know that law students have to have a total of 6 hours of experiential classes. So our appellate advocacy class makes up for 3 hours, and then they need an additional 3 hours. Well, one of the requirements for the law technology certificate is that the students have to do 3 hours of an experiential type course or a law technology experiential course. So we have a patent law clinic and a trademark clinic, so that counts. If our students do an externship in a legal tech focused company, that will count. I teach an experiential class, an AI legal reasoning class, which I designed so it's experiential, so that satisfies both the legal tech certificate component, but also the experiential requirement. The students who are eligible, of course, you've got to make it through the 1L year. Students have to have a 2.0 3.4 GPA, but I tell students, even if they don't have the GPA, still act as if, and once you hit that threshold, then you can, plan on earning the certificate, but we don't want to distract those students who kind of struggled that first year. The other thing that I really wanted to emphasize that's really important to us is the pro bono requirement. So all of our students who are earning the tech certificate, they have to earn 25 hours of legal tech related pro bono hours. And so we have a wonderful director of our pro bono program. She did a deep dive into Gavel. We have a law school license for Gavel, so all of our students can have access to it, professors that want to have access to it. Our clinics have a tech component to it. We've had our students who have design forms through Gavel. That's just one aspect of things that they can do. But one, we want to encourage our students to do pro bono for all the reasons that have been discussed. So Kristen discussed it during her keynote. Several of us are in the access to justice space, so we want that to be a core component of our certificate program. The other thing that I want to just kind of highlight really quickly is we have a growing data privacy, cybersecurity, and AI governance component of our certificate. So students who want to specialize within that space. We have an educational partnership with the IPP, so we're able to offer our students at a significantly reduced rate access to their SIP US, SIP E, at least those two, the materials and the certification. Our students who want to earn those certifications can take a data privacy class that either focuses on the EU or the US. The final exam for those classes is the SIP US or SIP E certification. So the goal is that students who know they want to focus in that area, that they will have that professional certification before they graduate from law school. We are expanding that to include AI governance. I am teaching an AI governance class this semester. I just recently earned my AIGP certification. I told my students when we started the class, I said, this is an experiment, right? I don't have the certification, but I want us to kind of learn together. And so I had to take it before the end of the semester so I could make some adjustments. So everyone knew that I was sitting for this certification. So fortunately, it worked out well. But the whole point is, as we're thinking about what the job market is demanding and where we need to have lawyers develop their expertise, we want to make sure we're setting up our students so that as soon as they graduate, they are already head and shoulders above law students who may not have yet been able to avail themselves of these programs. So that's just, one thing that I could highlight, well, the pro bono and that. Many more things that I can say about the program. I'm happy to share this LibGuide with anyone who's interested, and I will end it there.
Thank you, April. Quinten, I'll invite you to share more about kind of pockets and examples of some of the programs in Suffolk's Lit Center and Lit Lab.
So you already got to see a little bit today about some of the projects that we highlight on Court Forms Online. So those projects can start in our Lit Lab, the clinical program that we have. Sometimes they're started by people in my seminar who kind of have one semester, maybe the second half of the semester, maybe even to prototype a solution, and then it can live on. That's kind of the core of what we do. Is we're, with the document automation and the document assembly line, what we're doing is we're building these kind of guided interviews that then we can sustain. And you heard about one of those projects that was built 5 years ago that we're updating now to make sure it stays in compliance with the law. It's one of the exciting things that we can do with the lab. In terms of our collaboration with courts and legal aid programs, one of the things that we realized really early on was that a lot of these tools won't succeed unless people can do the whole process from their phone or computer without having to switch to a different tool. So we worked on integrating electronic filing. I believe we are the only nonprofit electronic filing service provider with Tyler Technologies, who's the big player in the court space. So we have that ability to take at the end of the guided interview process, you click a button, it actually files it into the court docket. And that's what's leading to our collaborations with the appeals court and the trial court here in Massachusetts, as well as in Illinois and hopefully more states to come. Something that's kind of neat about being the innovation lab is that we get to try new things too. We want to keep those things that we sustain and can build on and develop and maintain over time. But it's led to some really exciting new collaborations. For example, this year we've started working with the American Arbitration Association on their online dispute resolution process. We're going to pilot a project here in Massachusetts that's focusing on family simple divorce cases, ones that are really hard to get representation for in legal aid, or to solve on your own. A lot of people just can't afford to get divorced. It takes years maybe before they're actually able to finish that process. So we're piloting ways to solve that with the help of technology, thanks to the help of the AAA. And we'll be doing that as a full clinic next year. This semester, it started as just a seminar class where we're doing some of the design, prototyping, and thinking in advance. Next year, there'll be a clinic with students who can actually help take some of those cases on from start to finish in the arbitration process, or the dispute resolution process, not arbitration. So I think that's a good summary of the projects we have.
Thanks, Quinten. Jack?
Sure. So I think my lab might be a bit of an odd duck up here, and I'll talk about why. I'm hoping that exploring what we're for might be helpful for everyone from, especially folks from different universities, thinking about how to borrow some of what we've learned. And we're an odd duck because we are an instrumentality of a faculty member in his research agenda. My faculty member is Jonathan Zittrain, who co-founded the Berkman Klein Center for Internet and Society and is also the faculty director of the Harvard Law Library. And so has a broad research agenda that is about how is information changing our society and how can we help society thrive with the world that we now live in. And there's a lot of different ways that a faculty member could pull that thread, but the way he's done it is to create a lab of people who can make things and try things, which is unusual and weird, and worth looking at how we got there and then what we can do with it. So we are a library innovation lab, and I think innovation gets used as a like a word that gets slathered over either like we're not going to fix this problem or we're going to fire you. Like it's not usually offered in a helpful way. But I think that what innovation means at its best is how quickly can we test the way out of the trap that we're in. When someone says you need to innovate and they mean it, what they mean is you are stuck somewhere you can't be for long, and we need to start learning faster than we've been learning before now. I'm a library innovation lab, and libraries are kind of a great example of that because a lot of the best work that a librarian can do is make sure the next person does the same thing that the last person did. We have I think something like 39 early copies of the Magna Carta at the Harvard Law Library, because we are like a library of record for the world, and so we keep things like that. And the way that you get a bunch of like documents from the 1400s is you make sure that you pass it on to someone who will pass it on to someone the same way you did. But like every other library, we cannot assume that the next generation will be the same as the last 100. And what I want to say to you is, of course, like every other law school, like every other law firm, you cannot assume that the next generation will be the same as the last 100. We are facing deep disruption. It is not at all clear that the 3-year law school will have much value in the long run. And if it does or doesn't, it'll be because of the invention that we do. So I really like thinking about innovation from that perspective. The examples of the kinds of problems that I'm thinking about now, I think there's kind of 2 deep information problems that face all of us and that certainly face all of you as well. One of them is the one copy problem. We've moved from paper to digital, and on the internet, there's intense economic pressure to only keep one copy of everything. In legal terms, that means the copies of decisions of agencies, the copies of statutes and the records that went into making them, and the regulations. Right now, there isn't a place to go to get a copy of the law if you want one. But if there was, there would only be one version. And if you needed to see if it had changed, there wouldn't be a way to get that. But that is true of every other kind of important document that we rely on and that the legal profession relies on. This week, there was much question about whether the national weather data would stay online or would disappear. And that is just one of many examples of data that is vanishing. So that's one piece of things. Like we can't keep a memory of where we came from. The other thing that's happening that we've certainly seen today is that AI is rewriting the ways that we think about knowledge. And as a library innovation lab, that's very much on my mind. Whatever else it turns out that AI is, it completely changes how do you make sense of a pile of information, a collection. In another part of Harvard, there's the Emily Dickinson collection, which is a collection of Emily Dickinson's papers. That means they're now in possession of an Emily Dickinson simulator. Not the real Emily Dickinson. The simulator is very different from the real person. But the simulator is there and matters and is important in ways that no one knows how to work with, how to make sense of, how to lead well with. Or closer to home, we made the Case Alexis project. We have 7 million cases, now part of the collection of the Free Law Project, thanks to you all. So we have these 7 million cases. We have a judicial case simulator. What does that mean? How do we use that or not use that effectively? So as an innovation lab, we're sitting on these collective problems that our cultural memory is fragile and disappearing and subject to intense threats. And at the same time, the meaning of having a cultural record is rapidly shifting, and it may be much more powerful than it was before. So a very practical thing that we're doing just in the last few months is a project to preserve federal data and find new ways to store it and new ways to understand it, which started with a full signed and time-stamped archive of data.gov, 300,000 data sets from the federal government that we now share as a lab and are working on interfaces for, and making sure there's copies of in the United Kingdom and in Australia and other places, each as authentic and as usable as ours. But in some ways, I think what is it this week is less important than we really need this to be copied if we are to get out of this trap. When I get up in the morning, it's like, which thing should we do? And I say, wow, there's 20 that we should do, and we're going to do maybe one of them. What I most want to say from stage is like, how do you steal this idea? So I've been talking for too long, but I'd love to poke more at, I don't think you have to be Harvard to carve out a team whose job is to get us out of the trap. I think, in fact, if you're not Harvard, you should do that even harder and faster. And I'd love to talk with people about how that gets done.
Thanks, Jack.
Channeling Abby Hoffman there. Yeah.
Quinten, do you want to respond to that? Okay.
No, it's okay.
Go ahead. I asked the panelists to give some thought to kind of nuts and bolts, pros, cons, advantages, and disadvantages of this work. This is very different than traditional legal education curriculum, and there's a lot of good that comes from that, but some challenges as well. So maybe briefly, if the panelists can weigh in on, again, pros and cons, pluses and minuses, challenges and opportunities.
I think one of the biggest pros for our students is that it's so different from their other classes where they're just like trying to learn a lot, cram a lot in their heads. And this is an opportunity to actually go and do something, to build something if that's part of the project. As part of the discovery process, the design process, they have to go and talk to people. They talk to lawyers, they talk to pro se litigants, they talk to people who never turn into pro se litigants because they just don't show up. They talk to people at the courts, like everybody that's interacting as part of these systems. Not only is that valuable career-wise, but they really enjoy it because it is a chance to do something that's less theoretical and more practical. So that's one of the big advantages. One of the difficulties is that this kind of stuff is time-consuming, and they're doing a lot of stuff. And for our design lab, we use the design sprint methodology, which usually is supposed to take like a week. We do it in a semester because it takes a lot of time and resources. And it is a little bit resource intensive from a faculty perspective as well, having people and the right people with enough time to give to it.
Okay, I'll go. So many more pros than cons. I'm going to piggyback on what Nick was saying in terms of these classes are different from the other classes that students are taking, but it certainly does supplement what they're learning. So, Dyane had mentioned, law school is being taught the same way it's been taught for years and years and years and years. And part of that is because law professors are not trained educators. We teach the way we were taught by professors who teach the way they were taught. And when we think about how technology is disrupting this space and how you have to have foundational understandings as it relates to technology, it requires the students to take what they've learned in their doctrinal class and then see how that fits into this new world. And it will help them. It's like you can't code if you don't understand the underlying doctrine. So when you have classes where you're teaching students to code, so my AI legal reasoning class, I had my students learn Python and actually kind of think about a legal concept and how might you code that. Well, it required them to have a much greater understanding of that underlying concept. So to be able to take the technology and help them understand the doctrine better is just a really wonderful space to be in. The other pro that I'll emphasize is, for me as a professor, it is really exciting being in a classroom where I am learning right along with my students. So this AI governance class, like, I was very transparent, incredibly humble. It was not the situation where I'm, the person at the podium who is espousing this information to these young people and helping them go out and fly. We are still kind of all in it together. And that's a wonderful space to be as you're reaching the other side of your kind of career, and to think about this growth mindset that we tell our students they need to have, and to be humble enough to say, I have to adopt that as well. And to be forthcoming with the students and say, I don't know necessarily everything, or that's a great question, or bringing in guest speakers who are actually practitioners in this space. I'm not a practitioner any longer, right? So you just have to kind of think about education and the moment that we're in a different way that's actually, quite frankly, very refreshing. The con, I would say, is tied to that, which is it can be really challenging to get your colleagues to think in that same way. And that's why I kind of started off by saying, I'm so excited to be here, because it's wonderful being in a room and in a space where people are excited about the technology and thinking about education and the law in a different way. And we are, I dare say, an anomaly within our own institutions, right? There's a couple of us. I think Suffolk is a little different, but for most of the law schools, you can count on one hand the number of professors and administrators that really get it. And so we're still kind of trying to permeate the academy as a whole. And so I would say that that's one of the cons.
April, I would say, here at Suffolk too, right? There's still some convincing to be done. Although our dean, Andy, who you got to see at the very beginning of the program, has been a wonderful supporter and leader in this tech space for a long time. There's still some convincing to be done. I also see lots of pros in terms of what bringing this kind of different kind of innovative space into the law school can do. For our students, it's often one of the most exciting, interesting, different things they get to do. It's also often one of the most challenging things that they do too. So that's a trade-off for them. They might take a lot more time than they expect. If their homework for a typical seminar is to read these, they kind of know, okay, I can skim them, get this much out of it, and I'll be okay. You can't do that necessarily with a computer programming assignment that has to work or not work at the end of it. It just takes a different amount of time and different commitment to the time that's already in the ABA standards, I like to remind them. But it's very rewarding. I think it's one of the most creative things you can do in law school, is to build a project start to finish and see how it actually impacts people. And that's usually like one of the most rewarding things for our students. Like all of the students who are working in our lab are going to have a thing that's an artifact that's on our website that's going to help people long after they're gone. And that's a really exciting part of the work.
I was just thinking, I work in the Christopher Columbus Langdell Law Library, is the full name, for Christopher Columbus Langdell, who was the dean of Harvard Law School in 1850, and I'm sure there are others, but is one of the people credited with inventing the case method that we still use today, 175 years later. Yeah, right? I mean, that's too long. My brain said, wait, that's too long. No, it is 175 years later. And like, we've done some research since then on how you do education. Like, there's updates. Like, and many schools of universities have adopted that. Like, courses in many schools are not taught the way they were 175 years ago. And it's not like, oh, it doesn't apply to law. It's like, no, we just didn't need to. And I think if you think about that, it's damning. We were talking earlier this morning about unlicensed practice of law as a guild, as a protection that says, you're not allowed to compete with us. in the same breath as saying 90% of needs are unserved. And if you say, wow, 90% of needs are unserved, and we have a guild that doesn't let you compete with us, and we do education the same way we did 175 years ago, it kind of looks like we don't care. Like, we've decided it doesn't matter whether this education functions or not, because that's not what affects the success of the students. And I think I got to this train of thought because I think the challenge in trying to introduce this kind of curriculum is that you have to place a bet about whether we care or not about the success of teaching our students, and whether it matters to their success. If what they need to do is get an internship at a good firm and then go work at that firm and then have the same career, there's a good chance that some of this curriculum won't help them. Well, we could argue about that, but it's not necessarily what it's for, because a lot of the ways that we're designing this stuff is not keep you on the path that existed, but be prepared for a path that you might have to invent. And no, I won't stand by that, because I'm sure it would help them very much today in a large firm to be entrepreneurial, to be able to think creatively and to think client-centered and all of those things. But also, if they didn't do it, they might be fine in the law firm world of 20 years ago. A lot of the curriculum development that we're talking about here makes a bet that this can't last, that, as Ben said this morning, that UPL will not stand, that these systems will fray, and that the students that we teach should be prepared for a world where they need to be entrepreneurial and creative and thoughtful about client needs and deliver value and address the other 90% in order to succeed. And so my provocation is like, well, we kind of have to be right about that. Like, because if you prepare someone for a different world than they're going to experience, then you're doing the wrong thing.
I'll jump on that, Jack.
Can you have your cake and eat it too? Do you have to predict which world is?
I'm sure, April, you have something to say about that too, right? But like, yeah, here at Suffolk, we've always been really focused on building practice-ready attorneys, and many of them, we have our accelerator practice program, which means when you're finished with law school, you are ready to start a solo or small firm.
Which I would say makes you unusual in law schools.
I think so, but I think also, at NCCU, historically Black College University, same kind of practice-ready focus. There are more and more of us, but I will say that this is what we're seeing, is that I think that our graduates, and I don't want to speak for you, April, but maybe yours too, are already on that leading edge of having to be innovative and scrappy, starting a small firm. Is someone teaching you to be an entrepreneur and run a business in law school? Well, most of the time, no. Those are different skills that you get by joining a big law firm, and different skills that you need, I think, to succeed. So we're seeing some of that. I think there's more pressure at that side of the market right now than there is at the top of the market and in the large firm world, but it's going to come. I think that's what we can see, is that we're, in this part, maybe a little prescient on the leading edge of that.
And just at the risk of losing the crowd, I should add the asterisk. I didn't go to Harvard. I went to Northeastern. Really, what I want to say is that I think the Harvard approach becomes too influential. Not that it is the world as a whole, but I think that you're right that flip side is so important.
Mm-hmm.
And I think there's a lot of it depends, right? Depends on the school, depends on kind of the nature of your graduates. And might I add, see also bar exam, right? Law schools have kind of the big bad elephant in the room of preparing our students for success still today means, frankly, teaching a little bit to that accreditation exam and keeping up with other ABA requirements. So there's a lot of people knocking at the law school doors to do a lot of things. I don't know if, April, you want to add NC perspective.
Yeah, and I want to add to what Quinten was saying. Depending on the law school, right, the students or graduates may not all go to large law firms, but this point about every single law student needs to be exposed to the technology and what's happening in the space applies regardless of where the student or graduate goes. There is not a single solitary substantive area that is not being disrupted by technology in some way, shape, or form. You cannot be a corporate lawyer without understanding AI governance or data privacy or cybersecurity. You cannot be a criminal defense attorney without understanding the impact that AI is having on evidentiary issues. So it doesn't matter where you're planning on landing. Legal educators have an affirmative obligation to make sure that we provide students with the information that they need about technology and how technology is disrupting this space.
So should we resolve? We have no fear that we might move too fast on this issue.
I don't think so. I think there's also something to be said, right? Like, it doesn't matter necessarily what that intersection is, But I would argue that any teaching of legal reasoning without tying it to substance is doomed to make you not adaptive or adaptable to changes in what might be coming. Just being forced to kind of challenge your own thinking about how you learn and apply it to real specific kinds of things, and understand, like, if it's business and law, if it's technology and law, if it is environmental science and law, you know, those intersections, I think, are where you start to develop critical thinking. And I think that has value, even if the specific thing you do is not be a computer programmer in a law firm, right? That's not what our graduates are doing. But I do think that learning carries over.
Quinten, I'm going to use that kind of word value. This morning, there were some great questions in response to Kristen's keynote about, is it working? Like, how do you know if something's working? Should you publish? Should you do studies to show it's working? So I'm going to pose the question to you all. How's it working? How do you know? And we love that word assessment in legal education. Both, how do you assess your students? Nick, you mentioned pass fail. This is a different look than an exam and grading. And also programmatically, how do you assess if someone says, hey, you've done this lit lab for 5 years, is it working?
It's a tough one, and I wish I knew the answer. One of the challenges is that when you're doing something innovative, some things will work and some won't. And so when you do have those failures, I think there's still successes in terms of learning, but they might not be viewed that way from the outside, and you have to maintain, you know, support, institutional support for your program. Fortunately, that hasn't been a big issue for me, but I think it can be, because when you try something and it doesn't seem to work, you may. And so when you're reporting to somebody about how well this is going, I think you have to frame it that way. And even before you get to the assessment point, when you're pitching something, you have to set that expectation. Some things will work, some won't. But I do think a lot about how we measure outcomes, and I don't know if it's been long enough to measure a lot of outcomes. I think we'll kind of see that as the graduates go on. But I do think a lot about trying to make the class generally applicable, make the skills generally applicable, so that they are innovative when they go on into their workplaces, whatever those are, because wherever they are, they have a process, a problem-solving approach, and if they haven't thought about it, well, that's a problem. And these kinds of classes teach them to think about what that approach is.
Yeah, as far as metrics, so we do a couple of things. We've been tracking the students who have earned the law technology certificate, their bar passage, and kind of comparing that to the bar passage of the entire school to see if that exposure to the technology in combination with their doctrinal classes, whether that makes it a little stickier when we're thinking about the bar. Now, of course, students are self-selecting, so those same students are the ones that, you know, may have passed anyway, but, you know, you gotta be able to track the data. So that's one thing that we're doing. The other thing that we're doing, and again, we're just like maybe, you know, we're getting ready to graduate our 3rd class with the certificate. But I mentioned the CIPP certifications. And so the last time I took a high stakes exam was when I took the bar exam, like 20 some odd, 30 years ago. I took 3 separate states, and the first one was 30 some odd years ago. I have so much more empathy for my students now when it comes to just, you know, that the anxiety associated with the exam. But I will tell you, for our students, many of whom are first-generation college students, first-generation law students, don't necessarily perform exceedingly well when it comes to standardized tests for reasons that I will not get into today, but them having this high stakes exam separate and apart from the traditional law school exam does something to them in terms of their understanding of what's to come. So I'll just give you one example, and this is just anecdotal. So there was a student who sat for the CIPP exam. She did not pass the first time. It was in her, maybe the summer between her 2L year and her 3L year. She took it again the fall of her 3L year. Based on her indicators coming into law school and based on her indicators during that first year, she was in the danger zone in terms of passing the bar. She passed the bar the first time, She was in that building every single day over the summer. Well, not every day, but for the 90% of the time. And my assumption is, and again, this is just kind of anecdotal, is her having that early kind of failure, if you will, really kind of clicked in her mind about what is required to pass the bar. It's not about aptitude. It's about, because if you've made it to law school and you've graduated from law school, you have the aptitude to pass the bar. So much of it is understanding what the preparation looks like. Well, her having done that gave her an insight that she otherwise would not have had, right? And so one of the other things that we're tracking is for those students who earn their SIP US, their SIP E, their AIGP certifications in law school, what is their bar passage rate, right? And so when you think about, when I'm thinking about who are we serving, my particular student population in terms of, first generation, they need to pass the bar the first time. They need to be able to get these jobs that are incredibly high paying, that can change the trajectory of their families in amazing ways. But this is also why we require pro bono. We don't want to just place them in these high-powered jobs. I mean, whatever they want, I want to support them in that. If they want to work for legal aid, we've got a really good partnership with Legal Aid of North Carolina that Kristen kind of highlighted. And so we are mission driven, but for those that want to go to the large law firms or the Intels or the IBMs, we want to support them in that as well, but we also want to give them back. So the metrics and the numbers and the data, it's very important to us, and we're going back and thinking about how we can refine our program so that we can be able to have those metrics and demonstrate the return on investment.
And I'm mindful of time, but Quinten, I'll ask you, do you grade your classes like traditionally A, B, C, D? And how have you had to think or rethink about that given what you're teaching?
So yeah, we do have grades, but somewhat holistic. So I'm not necessarily thinking, does your program run without any errors? If you're building something that's more software heavy, students have a range of tools they can use to be able to demonstrate it in the seminar. And there's a lot of support on the way, but I'd like to see, I try to give them many different ways to be assessed that can play to everybody's strengths. They can the chance to work in teams, which also allows them to do some balance of the substantive legal work versus the computer software heavier part of that process. But yeah, they do get a grade, and it is a traditional, A, B, C. I have the ability mostly to give in the higher range, and I mostly do. I know that's not everyone's preference, but
students in the room are sweating. To the different skill set, though, that was, I think, what was frankly so fun for me, and maybe for folks in the audience. We think of law school as kind of these big time tests, and I'll say blue book, but no one uses a blue book anymore. But to see students get to perform in the way they did today, giving an oral presentation, right? That's a different skill set upon which that we're able to assess our students. I think that was a terrific example. I'm mindful of time, and I don't know if she's in the room. Kathy Vinson, a colleague of mine, ended a panel in the fall doing rapid fire in a very fun, random sense. And I said, that was a great way to end a panel. I'm always going to do that in the future. So I'm going to walk the walk. So one word answer, panelists. That's all. First, coffee or tea?
Herbal tea.
Coffee.
Tea.
Coffee.
I'll note for the record, Nick already broke the rule and used 2 words with the first response. Zoom teaching or in person?
In person. That's hyphenated, right? That's
In person.
In person.
In person.
Okay. Red Sox or hybrid. Thank you. Red Sox or Yankees?
Tigers.
Red Sox?
Right answer, April.
Right? Okay.
April's remembering what state she's in. It's been a long few weeks. Quinten.
Red Sox.
I'm an ultimate Frisbee player myself.
I like it. I like it. Claude or ChatGPT?
ChatGPT.
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 Claude.
I like it. There's our empirical evidence for what tools folks are using. And finally, casual fireside chat or formal panel table with slides?
Fireside.
Fireside.
Yeah, fireside chat.
Fireside chat.
And there we are. So thank you all for your attention. David will tell me if we have time for 1 or 2 questions, but I'm sensing no.
Oh, we could do 1 or 2 questions. I love questions.
We have lots of questions.
We have. Landon's going to run with a mic. Oh.
Thanks, guys. That was really, really interesting. Quick question. Are you aware of any engineering programs where they're teaching their students about building legal tools?
Engineering programs.
Doesn't Dan Linna teach in the engineering and law schools?
Yep.
That's the only one that comes to mind.
Yes.
Stanford.
Yeah, design.
Cornell, Stanford, Northwestern.
Ryan is here.
I will say I teach a combination class that has master's students in the School of Library and Information Science and law students. And I've connected with someone at NC State. And so we're hoping to do something like that. But I think those hybrid classes where you have students from both disciplines is, yeah.
We do some of those. Professor Zitrin is doing a AI agents class this semester that has both law students and engineering students in it. There's also a class CS 109B that takes, it's an engineering class that takes actual data problems from around the university and puts engineering students on them. So we've given them legal challenges from time to time that get the engineering students thinking about it.
Yeah, I know Ryan Sullivan's here from University of Lincoln. You've done some projects that are kind of sharing that as well, right? And I'm going to highlight Kevin Ash starting a project. I've been a guest with Kevin Ashley's class at the University of Pittsburgh, and his law school class, it's project-based, and it invites computer science students and law students together. We have tried it, and we haven't had like a durable, sustaining project that combines computer science at Suffolk with our program, but it's something we should keep trying.
And also the business school. So we've been collaborating a little bit more with the business school, and our new LLM and LLM, as Dean Perlman phrased it, students will have the opportunity to take some of those business school classes on innovation and collaboration that are kind of a different angle to what we can offer. Landon, you're in charge back there.
Hi, first of all, I have a quick observation. That's not a question, but I do promise I have a question. My observation in response to Jack, I went to Harvard Law School and I didn't understand torts until I took Barbary. So make of that what you will. My question though is for Quinten. Are you doing any evaluation of the tools that the students are putting together after they've been in place for longer than the end of the semester?
Yeah, we do 2 kinds of evaluation. So one is that we do, when we can, we build in time for usability testing. And that's something that we've been trying to build more capacity for. So that's usually observational. We're looking at real users of the tool as they go through it, and we're making note of areas where they have difficulty. We also look at analytics. We gather analytics to understand where forms drop off, and we try to gather usage numbers. I think we could that could be a whole assignment for a student in itself, and we haven't done that. I'm sure we could improve, but we definitely do try to do that. I don't know if that's enough of a complete answer, but yes.
Yes, in the front.
Hi, this is also more of an observation. It seems like your clinical programs are actually focusing a lot on communication, which I don't think has been the traditional strength of law schools. And because you can make programs that run, but if the clients can't use them and understand them, then you've really lost out. And so I just think that's another strength of programs. That's a really important skill, and certainly not something that when I went back to law school in the dark ages was not necessarily a focus, and I'm not sure it's a focus now. So just more to add to the kudos to what you're all doing.
I don't want to put anyone on the spot, but I'll say it. Yeah, our mutual friend Caroline Robinson makes a good point. It's like, sometimes if you're working on legal content, lawyers don't always agree on the first draft, and sometimes it's because they don't actually understand what it is that they're trying to explain. We fall back on legalese so much as lawyers because it's hard to actually understand and explain those concepts.
All right, one more, Tony.
Oh, well, actually, thanks. Someone back here had a question. I've already asked like 2.
Thank you so much. My name is Brian. I'm a 4th year evening student at Georgetown. Also, over the last year, I've made a couple apps to try and make my life easier as a law student, more efficient and accessible. But my question is actually about where legal learning happens. I've always found it disturbing that like you can go on YouTube and watch a quantum physics lecture from MIT, but not a contracts lecture from most law schools. But the average person, I think, is more likely to need to understand how to interpret their lease than to build a quantum, particle accelerator. So my question is, must law schools stay closed source, or are there ways that we can distill legal education for a broader audience of advocates who may want the knowledge and also the skills to be able to argue whether it's a hot dog or a taco without spending $100,000 or $200,000?
Thank you for that great big picture question to end on. Jack.
Can I? Yeah, I'll climb on that soapbox. Absolutely. Yeah, and I think so many of us are here because of feeling that same push. And our open casebook platform, when it started in about 2002 or something, they had to call them playlists instead of textbooks because it scared the law school to like take a course and put it online. Like, that's our IP. So they're like, don't worry, it's a playlist. It's fine. And I think now there's a lot more comfort with putting legal pedagogy online. But that was where law schools were coming from. And I think the schools are ready for that now. I think there's a lot of room for kind of blowing the doors off the law school. But I think it gets back to the UPL problem that having this bright line between you're either doing law or you're not, and if you are, you have to do it in certain ways, and if you're not allowed to do it at all. It chills so much all of the middle ground that would exist to help people. Like, maybe you could watch a bunch of YouTube videos and become the barista who's the best at helping the other baristas with their legal problems. But no, you can't, because that middle ground isn't allowed to exist. So I think it's so important to do, but I think we have to really fight for the guild to let off a little bit so that we can make that space to let people get somewhere if they invest that time in learning. Because otherwise, well, you can give them the materials, but what are you really letting them do?
We shouldn't go without a shout out for the Lit Lab and like all the stuff that they put online that I refer to, the document assembly project, all these videos on YouTube, all these tutorials. That stuff is great.
And we have
Thank you to our panelists.
All right, we now have a scheduled break, and we'll be back for our next panel.